Hi, everyone who's coming back. We seem to have some technical difficulty and we all just froze and it went away.
Just to let everybody know, we were all booted out and we all just came back in. It's been an exciting evening so far.
Oh, yay.
If
I
you're
told
like,
you it
what
was
just
going to be
happened?
interesting. I told you it was
We
going to be
experienced
fun.
the same thing. We were
Okay.
sitting there.
All right. Yay. Okay. I'm going to
So
go.
there are some questions about money. Should we talk about the money?
Yeah. Why don't we do
So I
that?
have a few ideas because I mean, this type of planning is expensive. You know, it does require expertise. It's difficult to do on a discount. I just want to be honest. Now, I do have one client who advocated for herself with her regional center, and that was Golden Gate Regional Center. And she had our services added as a vendor to her child's self-determination plan. And so basically, the self-determination plan paid for our services. Now, I've spoken with other people who deal a lot with the regional centers, and one person let me know that Golden Gate Regional Center and West Side Regional Center, I think that's the name down like Santa Monica area. Those are the two most lenient or progressive regional centers where you're most likely to have success naming an attorney or a financial advisor's services as a vendor and have it covered. There's some that I've heard do not at all, like East Bay Regional Center. I've heard from them never ever. I think San Andreas Regional Center, it's a case, each one is a case by case. So it's worth trying for sure, okay, to try to include our services in that. I can also say it's my goal in the next several years, has not happened yet, but I'm looking into it, to start a nonprofit organization where we can provide services for reduced or no fees for those with more modest estates. We're not able to do that yet, but it definitely is in the plans. So we recognize the need.
And just to know, am I the only one? No, here I am. Just to know that with the self-determination program, um, things are changing on the daily because of budgets and funding, and larger budgets are being more scrutinized. So, might not be the best time to be asking for something like this, which is a little out of the ordinary, but you can certainly try.
Doesn't hurt to ask. Yeah.
Right.
And many times as we do the financial planning process, we uncover maybe benefits that they're not getting, maybe they've been denied SSDI or something when they could have been. A lot of times we find additional funds, or making financial decisions that in the long term will save you some money. So, but we see that a lot. I wanted to bring up conservatorship real quick. So PHP used to do a presentation and for conservatorship. Sometimes you need an attorney, but there's sometimes you don't need an attorney to do the conservatorship. So that's something to take a look at as well.
Well, Ellen, so there was a question that was asking about the difference between a special needs trust and a dynasty trust. Do you want to touch on that a little bit?
You bet. You bet. Now, before we go to that, I actually do have, somebody was asking the code. Oh, I don't have it. If you reach out to my office later, oh, there we go. The possible service codes for the self-determination plan, try these: 340, 333, 320, or 366. Give them a try. Okay, so moving on. So a dynasty trust. I know. I'm like, whatever those numbers mean, right? They're each associated with this type of vendor, that type of vendor. Okay, so sometimes it comes up, what if you have a neurotypical kid, or what if you have a child who's never going to receive public benefits? Maybe they have an emotional health challenge, or they've worked for a bit and then they're not able to work, but they can't qualify for public benefits because people say, well, they should be able to work, or maybe they can work in the future. Then you can do a different type of protective trust called a dynasty trust. Actually, these are called a lot of different things. Sometimes I call them a lifetime trust. I've seen many different castle trust. You'll see different names for it, but basically it's an asset protection trust. So the idea is you set it up for your child. You can't set it up for yourself, but you set it up for your child, and anything that goes into the trust is that child's own separate property, and it remains their separate property. So if they get divorced, it doesn't go to the horrible ex-spouse. It's also protected for creditor protections. Okay, so if they get sued, then they should just back off of acting as trustee. Somebody else can act as trustee. Very good creditor protections. There's also a really good estate tax protection. Anything that's in the trust that goes to your child's children is free of estate taxes. So if you have a larger estate, that can be a really good, and that's actually the reason why dynasty trusts were created in the first place, was to protect the dynasty, the estate of the family. But we found that the first two protections are usually the ones that our clients really like, the asset protection and the divorce protection. And so those are, you know, we do a lot of dynasty trusts for families. We find them to be really protective, really powerful.
Yeah. No, I think that's a good point about the two pieces that you find most favorable for families as well, right? Because oftentimes we'll see folks will think, oh, well, I don't need that. Like, I don't have this amount of assets or resources in my own personal estate, so why would I consider doing it? And, you know, it's actually the flip. Like, there could be very important reasons to consider as the piece of the planning puzzle for the neurotypical children that you wind up having.
Yeah.
Let's see. Oh, actually,
Now there's
someone's asking for your codes again.
For my what?
Actually, never mind. Alyssa posted your codes.
Oh, great. Okay. Okay. Now there was a question about whether dynasty trusts protect from Prop 19 impact. I have not found anything that protects from Prop 19 impact. There's really no way around it. What's Prop 19? You might ask. So that's if you're passing a house from a parent to a child, we have Prop 13, right? The property can't be reassessed while you own it. But if there's you know, a transition, a change in ownership, then it gets reassessed. But there's an exception. It used to be if you leave your house to a child, it's free from reassessment. That was Prop 58. That was actually changed in 2021 by Prop 19, which said only the first $1 million of reassessment from parent to child is forgiven, and real estate, rental properties, other properties besides the primary residence, those are all completely reassessed. The only way to get around that is really, really confusing. I interviewed Elijah Keys on my YouTube channel on this topic, and it involves setting up LLCs, and it only works if you have 2 or more kids, and it's just, usually it's not worth it. So unfortunately, we haven't found a way around that.
Okay. Well, I will say this from our standpoint, when we're talking about the primary home. So it's very common when families come to us and they say, hey, I want my loved one to continue living in the family home. That's what they know. That's what they're comfortable with. They say that they'll be able to take care of it. And Ken, I know you can speak to this as well. Well, what's one of the biggest expenses that we're going to have to now pay when there's a reassessment, especially for Bay Area homes where families have lived there for decades and decades? Property tax. And so when we're looking at not just how much money needs to eventually go into the special needs trust and then finding a funding mechanism, that is one of the biggest pieces of the puzzle. How do we have the resources to pay that new property tax bill, in addition to utilities, maintenance, and upkeep, plus other expenditures just for quality of life too? Right? And it becomes a very, very tricky topic in terms of how does one stay in that household that they're so familiar with. And that leads to a further discussion of perhaps it's time to explore other housing opportunities that might be available too, especially depending upon the resources that the family has to begin with. Let's see here. Are you guys seeing any other Q&A?
I see a question that I really like. Okay. It says, what are the advantages and disadvantages of having the special needs trust set up in advance as a standalone trust before the death of the parents versus a special needs trust embedded in our revocable living trust that comes into existence and funded on our death? That was a beautifully worded question, by the way. You really got to the meat of what this is. Okay, so it's really a structural question. When you're setting up a special needs trust, should you set up a separate standalone special needs trust that's created and effective immediately, or should you embed the special needs trust within the bigger revocable trust? And the answer to me is clear for two reasons. You want the standalone special needs trust. You might be thinking, what are those two reasons? Well, the first reason is when you have a separate standalone special needs trust that's effective immediately, anybody can fund it at any time. So if you have grandparents, aunties, and uncles who want to leave something to your disabled loved one, they can. They can change their own estate planning to leave money to your loved one. The second reason I think is even more important. When you die and money goes into the special needs trust, the successor trustee is required to report that special needs trust to the Social Security Administration if your child's receiving SSI benefits, or to Department of Healthcare Services if your child is receiving Medi-Cal benefits. And the government is going to look over the trust to make sure it's a valid special needs trust. Now, what happens if you send them this big long scroll of a revocable trust and you say, well, see Article 6. That's where the special needs trust is. It's in section, Article 6. These people who work for the government, who are underpaid and understaffed, they are not experts at reviewing trusts. They have no idea what it means. And usually the trustee succession is up in Article 3 and the alternate distribution is down in Article 9, and they can't follow it. And sometimes they even make you cut and paste the sections that might apply to the special needs trust so that they can see the full special needs trust. Don't do that to them. You just want, and also, this is your privacy. You're having to share your full revocable trust. If they see that you have a lot of money, or if you have more money, they might really start scrutinizing things. If you just have a separate standalone special needs trust, you just send in that trust. You say, here it is. They review it. It's done. So definitely do a standalone special needs trust, in my humble opinion.
Yeah, absolutely. I mean, to me, it's so Ellen and I and Scott, we belong to the Academy of Special Needs Planners, which is a nationwide group of individuals. And to me, we have a, I forget what it is anyway, where people can ask questions back and forth. I forget what they call it.
Forum.
Yeah.
Mm-hmm.
Yeah, it is amazing of what the questions and what Social Security does and puts some people through the hoops and stuff like that. It is just shocking, and it's a great way of just where you think, okay, well, gee, I've got everything done. Doesn't it just smoothly go through? No, there are so many different things. And unfortunately, some of the people at Social Security, they don't know the law sometimes, and it takes an attorney or an advocate to be able to make sure that these things go through smoothly. So you don't want to give them additional ammo to, critique your estate plan.
Mm-hmm.
That's right. Hey, I found a question for Scott and Ken to answer. Scott and Ken, is there a specific certification for a special needs financial planner?
Go ahead, Scott.
Yes, a chartered special needs consultant, CHSNC. Right. So just like Ellen, how you were talking about, there are a lot of estate attorneys that say they can draft special needs trusts. We find it on our end. There are a lot of financial planners that say they're planners, but one, don't have the certified financial planner designation, or say they work with special needs families, but they don't have the chartered special needs designation. So there are degrees of expertise in all respective fields. And so we notice the folks that are a little bit more committed have those additional credentials, and they work with the community on a very regular basis. And I think you'll tell based upon the quality of work, ultimately. But yes, there is a designation. And
by the way, he didn't say this, but they're both chartered special needs consultants, these two guys, Scott and Ken. So, yeah. Okay, another question. How do I find a corporate trustee? That's a very good question. There's really three categories that I think of when we're talking about professional trustees. The first one is a private professional fiduciary. So this is who's going to act as successor trustee of the special needs trust. Okay. That's not something, by the way, that attorneys typically do. They used to sometimes, most of them don't now. And financial advisors usually don't. We advise the trustees, but you got to have an actual trustee. That's the fiduciary. Okay, so you might find an individual, a private professional fiduciary. They're very good. And you could also consider a bank or a trust company. All right, there's pros and cons of each of them. I have a video called Who Should I Choose as Successor Trustee? And I go through the pros and cons of each of them. And if you'd like to reach out to our office, or I can even send out, Alyssa, if you want to circulate it, I can send out some lists of recommendations for private fiduciaries and for banks and trust companies, because a lot of what our firm does is we play matchmaker. We help people find the right people on the bus, the right advisors, the right trustees, the right care managers. So it's so important.
Yeah, so there was a question on CalSTRS, and so a few years ago now, disabled adult children who do not get married can now be the benefit of a CalSTRS or CalPERS pension, and so that creates some unique planning situations. Also, if there's a divorce, maybe there's child support, even when the child is above the age of 18. Those are all different situations that, you just can't use a boilerplate type of document to draft that. We get a lot of questions sometimes where somebody says, well, okay, I work at this tech company and they give us I've got this legal aid plan, and, for $99.99, I can get the legal trust done and all that stuff. Is that, we don't see a lot of, attorneys that specialize in special needs planning and stuff are on those lists. You got to go to somebody that knows what they're doing. And unfortunately, the employer legal aid plans really don't provide a lot.
Can I just say that it is 7:28, given that we jilted out there a little bit, can we stay on like another 5-7 minutes or so and answer a couple more questions? Is that all right with everybody? Okay.
Sure.
And also just to direct people's attention to the chat, I have put the links to the English evaluation and the Spanish evaluation. If you can click on that, 4 easy questions. It just allows us to keep bringing back presentations like this where we lose, Wi-Fi in the middle of it. Well, what more do you want, really? Okay.
I'm typing in a few answers.
Okay.
So let's see.
How about, do you need separate trusts for each of 3 children if you have 3 children who all have needs?
I think so.
I'll let Ellen answer that, because we've come across that where you have, multiple children with special needs. Do you do one special needs trust, or do you have to do separate special needs trust for each child? So Ellen, what?
Well, I have done a few what we call pot trusts, which is basically a big special needs trust for 2 or 3 beneficiaries. But I usually don't like doing that. And because it leads to a lot of fights. If one kid gets more than the other kid, then there's fighting. If there's worries about, is the money going to last, there's fighting. I really like each person gets their own inheritance. You can plan out their inheritance based on their life expectancy, based on their needs, based on this money, and then each person knows what they have. This is kind of similar to the concept of, a while ago, I think people used to leave all the money to the neurotypical kid and say, hey, can you take care of your special needs sibling? Such a bad idea. I mean, on so many levels, right? But one of the things is that neurotypical kid doesn't actually know how much do they actually have. They might want to invest in something. They might want to buy a house, but they're not quite sure if their disabled sibling how much they'll need, right? So leaving money specifically for each child, specifically in a trust. I know it sounds kind of complicated that way, but honestly, it's a lot simpler and more straightforward to administer.
Well, do you want to take it a step further, Ellen? Because this is something that comes up too. Like, what if I put too much in the trust? one of the kids passes away sooner than anticipated, what about the remainder beneficiary that's typically within the legal document too, and how that might work?
That's right.
Mhm.
Yeah, yeah, all of that.
Yes.
For many, many reasons. You want separate trust for each kid. That's typically what we see.
Yeah, so there's a question here about, managing the funds in the special needs trust. So one of the things is once it's an irrevocable trust and it has its own tax ID number, the tax laws change. So you have a very compressed tax rate. So when we talk about ordinary income for a married couple, you've got to be in excess of 700,000 of adjusted gross income to be at the 37% tax bracket. Scott, what's the amount if it's a special needs trust with its own tax ID number?
15,650.
Yeah, huge difference. So special needs trusts have to be managed in an extremely tax efficient way. And that's some of the complications where we say, gee, I'll just leave my big 401k or IRA to the special needs trust. That's, there's ways to do it. And there's things, but it adds a level of complexity in terms of the planning, as opposed to assets that would receive some sort of a step up in basis that would be going over tax free, like a life insurance policy. We want to be aware of the tax implications of funding that special needs trust as well.
Mm-hmm.
Yeah. We have people who think, oh, great, we can stretch out the retirement accounts over the disabled child's lifetime expectancy. How cool. But you got to make sure that all the income is distributed out each year, or you're hitting that highest tax bracket. So it's nuanced. There's no straightforward answer. You got to look at and crunch the numbers. And that's one thing that Scott and Ken are so good at. They're great at crunching numbers.
Mm-hmm. Yeah. And we like to do when we talk about being the parent's financial advisor and the child's advocate, we may recommend that they do Roth conversions and Roth contributions, because then we take that income tax out of the equation. So yeah, our feeling is we would rather have the parents pay a little bit extra tax while they're alive so that the special needs trust and their beneficiary pays less taxes down the road.
Mm-hmm. Yep. Okay, here's another question that I love that I'll answer. Can the grandparents set up the special needs trust for the child to be funded upon their death and the parents be the trustees? Can the parents then also designate money to be added upon their deaths? Yes, we love it when grandparents do this. This is a great way to support your disabled grandkids. You can set up the special needs trust and name the parents as the initial trustees. You fund the trust, but the parents get to manage that money, and the parents can also fund it. Now, please run the special needs trust by the parents first before you set up. You want to make sure that you guys are coordinated. So either the grandparent can set it up and fund it, or the parents can set it up and the grandparent can fund it. Sometimes grandparents have more resources than the parents, so they'll do the setting up. It kind of depends. I do have a video called, it's about being a grandparent of a child with special needs and doing that planning. But yes, I think that's a great way to provide for your special needs grandchild.
Mm-hmm. That type of trust can't be embedded into your revocable living trust. It has to be a standalone special needs trust.
There you go.
I'm just going to direct folks' attention again to the evaluations in the chat. English and Spanish. 4 quick questions. Okay, back to maybe just a couple of more questions. I don't want to keep everybody too much longer.
Okay, one question. Does the living trust affect public benefits? Well, usually the living trust is for the parents, and the child receives public benefits based on the child's own money. Once the child turns 18, the parent's money is not deemed to the child. It doesn't count as the child's money. That's why the child qualifies for public benefits when they turn 18, usually. So no, the money in the parents' revocable trust or the money just that the parents have does not count as the child's money and it shouldn't interfere with the child's public benefit.
Mhm.
I see someone asking about adding executors to a special needs trust now that the other adult children are older.
Sure.
Simple question.
Yeah. I mean,
Simple
it
answer.
depends, you know, if the trust allows you to change who the successor trustees are, go ahead and do it. Now, with that caveat, you know, do you really want to name the kids as successor trustee of their disabled siblings' special needs trust? Sometimes it works, sometimes it doesn't work. If you have a child, for example, with mental health challenges, please don't name the neurotypical sibling. Everybody in the family's been through a lot, right? If you have a child who's very compliant and friendly and has Down syndrome and loves everybody, then sure, name the neurotypical sibling. So, I mean, it really depends on the dynamic between the siblings. Um, you know, a lot of things. How busy are the siblings, right? Are they living their own lives? Are they going off and doing their own thing? There's many factors as to whether you might want to do that or not.
Mhm.
I mean, to me, the best role for a sibling is to be the trust protector.
I believe so. In most cases, yeah.
There was a question before we got booted off about what a trust protector is.
Ah,
So Ellen has a video for that. But
I do. I actually give a full-on presentation on that. I mean, I feel like I'm ready. Yeah. Okay, so a trust protector is basically an overseer. They're the ones who look into what the trustee is doing and make sure that the trustee is doing a good job. So they get annual accountings to see how the money is being spent. They have access to the books. So this is all spelled out in the trust. It says, you know, these are all the things that the trust protector can do. And they have the power. I like putting in the power to remove and replace the trustee. So they're looking, and if they see, wow, this trustee is not doing a good job and they're not responsive to my requests and direction, you can remove them, find another professional to put them in. This is a role that I found is a lot more palatable for other family members who are already busy living their lives. It's basically, it's a once a year check-in, make sure everything's going okay, check in with the beneficiary, see if there's any problems. And it doesn't have a fiduciary duty. The trust protector can't be sued for their role. And so that's why we make it a limited role. First of all, because they're busy and you don't want to give them too much to do, but also because we don't want to interfere with what the trustee is doing. They're doing a lot of work and they have a big responsibility under the probate code. But we also want to, you know, make sure that the trust protector is protecting themselves.
Okay, it's 7:38. If any of you see you have a burning desire to answer one more question, then please go ahead. But if not, any last words on this very truncated recording that we're going to have?
Well, I can't see any more of the Q&A, so
Oh no, again?
Oh,
anyone else sees one?
oh no. Well, I see one for Scott and Ken because I feel like I've been talking so much. There's one, it's
Here,
an investment question.
I'm
They're
making you
asking
host.
about passively versus actively managed funds for special needs trust. So basically, how do you manage assets in a special needs trust?
Yeah, so that back to the taxation. So a special needs trust, it's funded and again has its own tax ID number. It's a taxable entity. So we want to make sure that we want to try and minimize ordinary income being generated by the trust. You know, maybe it's muni bond income that we want. And we want to make sure that we're managing it towards, you know, long-term capital gains if there has to be, you know, transactions. But sometimes people go, well, gee, I manage my own IRA and I do a great job, and they're buying and selling and Bitcoin and do all this stuff. It doesn't matter because that whole registration, you're not impacted by taxes until you withdraw. A special needs trust, it's taxed along the way. So anytime you make a transaction, that's a taxable event.
Okay. All right. Anybody have any final words? Because I think we are done. We are done. Scott can't see questions. I keep glitching out. Ken keeps freezing on me for no reason. So any last questions? Any last comments? Okay. Anybody?
Thank you for having us.
Was yeah.
Yeah.
You're ready to come back, aren't you?
Yeah.
Do the
well,
survey. Do the survey, right?
Thanks, everybody.
Thanks,
Have a good
everyone.
night.
Bye.
Bye.
Bye.